Okay, so I'm going to try to do a real quick video on the origins of the powers that are now governing the corporate state in the United States. And it pertains to the capacity to affect municipal powers and corporations. This is a little deeper for some people, but it's important that you try to understand the origins. Basically, and I'm getting this information from books. One of the books that I have, it's the Federal Limitations Upon Municipal Ordinances, Municipal Ordinance Making Powers. And that was published by the Ohio State University in 1929. And there's another book, but I have sources for these. And if I'm citing case law, if I cite case law, I will put it in the body of the notes for this video. What basically happened in the formation of our country is that the concept of corporations were not original to the construct of our nation. Corporate charters and the capacity for corporate charters originated in the Roman Empire. The Roman Empire was an overseeing government. It would conquer regions, and then upon them lay municipal overlaying governances, where the people were not in control of those municipal ordinances. The Roman Empire was, and they were put there specifically for the purposes of protecting commerce. Sound familiar? If you study the Civil War, that's civil law. Roman civil law is what the corporate structure of the United States is operating under. So still, that's why if you hear me ever say we are under the Roman Empire still, we are. We are operating in Roman civil law. And the law that was brought to this land was brought forth and is Roman law because we are still operating under the banking trust of Rome. So after the Civil War, they instituted Roman civil law upon the land because the common law, the law side, had been vacated by coup and was never restored. It was reformed. So back to municipal powers. When we first came to this land and started our unions, municipal powers were controlled by the king. The king still, even in the formation of our colonies, was the one who afforded the franchises of municipal powers. Well, and the people who were given those were typically, when they originated in Europe, they were of the freemen. Freemen being the men and women, but it was rarely women. But the freemen were men who were above the state. They didn't need the instruments of state to survive. They were the landholders. They were the men of commerce. They were the tradesmen, the craftsmen. And those men were allowed to unionize and go to the king and provide them articles of assembly, corporate charters, let's say. And that the king would then, all you had to do is register them, and the king would then recognize you as a corporation. Well, so at the time in Europe, corporations were bodies of free men, and such as the Masons or unions, okay? So in Europe, those municipal corporation concepts developed as groups of people. Well, when they brought them over here, they kind of instituted them the same way. And our founding fathers, it was not too hard to write a constitution for the States of America United because they'd all come from Mason heritages that had constitutions within them. And most of those unions were developed for the purposes, they were think tanks. And they were there to improve the states of men. We think of the Masons now as not nice people, but that's not what they came from. They were couped in the 1700s, same time that our government was, and they were infiltrated. Much like Machiavelli says, the only way to really affect a coup in a free-thinking republic is to either make it set itself aside to vacate it, or to infiltrate by cooptation the instruments of state and put your own people in there. Well, that's pretty much what's happened. So they brought this concept of municipal powers to the United States, or the States of America United. They were colonies at the time. And they started to see the oppression of the king at the time, of the manipulation of these unions and the overtaxation and et cetera, et cetera. And so they revolted against the power of the king to control who had the capacity to affect the franchises of municipal corporations and who those corporations were beholden to. So during the Revolution, after 1776, what the Constitution actually established was the capacity of a single man or woman, now conferred. You know, the word men is in the word women, so all men are created equal. The word men is in there. But at the time, it was just men, black and white, by the way. Only that the individual man could be considered a corporation, that he had the right to independently, he didn't have to be a body, he didn't have to be a union or group, that the sovereign man was smart enough and enlightened enough and God-fearing enough that he could operate in singular capacity as a sole franchised entity to operate in commerce and to bring forth his wares as an individual, not in concert with others, not in cooperatives, but as a man, to the corporate side of government and bring his products of his intellectual property to be sold and traded, and that he could accumulate wealth from his individual mind, from his creativity, from the fruits of his personal labor. And that is what the Constitution established, is that all men singularly are created equal and have particular rights, and the right to contract is one of those. As a single person, not having to join corporations in order to access banking, which is what was required in a lot of ways internationally prior to that. So after 1776, the right for municipal corporations to franchise them was actually given to the legislatures at the will of the people, because prior to that, municipal corporations were never even granted in the colonies until the people themselves asked for them. Meaning, we got together as the village of Jamestown, and we want to be we want a municipal charter, so that all of the people who are in Jamestown who have wares to sell can work cooperatively and sell our wares to other cities, and we want those rights to international banking structures. And that's what they did. So it was then conveyed to the legislatures after 1776, because they certainly didn't want a new king and a governor to be the only one who did that. So the legislatures were given the right to form municipal corporations. Now, from that, we now have what a lot of people see as corporations, municipal corporations. Well, the distinction between municipal corporations and a regular corporation, because a regular corporation is considered an association of individuals with a distinct purpose, where they have to state those purposes in articles. And in the United States construct, or the States of America construct, it was the Articles of Confederation. If you look at the organic document, you will see that it is kind of a corporate charter. And it tells the people of the world why we are combining our minds to create a new government for the people and by the people, what it ended up being. So the distinction between what we know as municipal corporations and standard corporations is municipal corporations are what you see in cities and the like, right? The difference is municipal corporations are not voluntary. A standard corporation is voluntary. It's a voluntary jural entity, versus a municipal corporation is not voluntary. Now, the problem with them not being voluntary is it's fine and dandy whenever the powers of state, which is what the state has the power to provide franchises for municipal corporations. It's fine and dandy if the state is operating lawfully, because the state is supposed to follow a hierarchy of laws, and those laws are in this order, pursuant to the common law. And then I'll give you what the legal side is, because municipal corporations are a legal construct. They're not a lawful construct. Corporations there's no word corporation in the Constitution. So these are man-made law instruments in that they are legal. So legal is man-made law. Common law is God law, what we know within our hearts. So in the law construct, the common law construct, here's the hierarchy of law. The common law of the republic, meaning the body of the people, who created the instruments that created the state. So then those instruments come next. the Constitution of the United States of America is next. Or the States of America United is more likely how it should be parsed, so as not to be confused with the Constitution of the corporate United States. So we have the common law of the Republic of the People, the Constitution of the States of America United. Then you have the acts of Congress, assembled, and the treaties that they bring thereof, and that's a Congress assembled, no capitalization. Then you have the common law of the state republics, the territory Ohio, that became the state Ohio, which then became the state of Ohio in the corporate construct. So then the common law of the state republics, where the people banded together, and petitioned to become a true state in the States of America United. So again, the people wanted the franchise. So the common law of the territories, the republic of the state itself. Then you have the state constitution, which those republics created. Then you have the state statutes that the legislatures that were created by those state constitutions, that were asked for by the Republic of the People, create. Then you have municipal ordinances. Now, the municipal ordinances are the lowest form of law, okay? Now, according to the legal scholars, or the legal construct of things, this is their hierarchy of how they think it's supposed to be. They think that the Constitution of the United States is the highest order. Then the acts of the Congress in treaties, not a Congress assembled, the Congress, which is a corporate body. Then you have the national executive rules and orders. Okay, and by the way, there's no construct of executive orders in the organic lawful de jure Constitution. That is not a constitutional right. So that's a legal right that's been created. It's an expansion of the grant that the Constitution does not protect. Okay, the organic lawful Constitution does not protect. Then you have, after those, executive orders, which is basically rules of the king edicts, which is why they're not allowed in the Constitution. Then you have the state constitutions. Then you have state statutes. And then they put the common law of the state under state statutes. Then you have state executive rules and orders, which is strange that the people's law is above the governor's statutes. But the common law is not above the executive branch of the federal government's statutes. So that's beyond my comprehension how they rationalize that in philosophy or in law or in logic. And then you have municipal ordinances. Regardless, municipal ordinances are on the lowest platform. They are the lowest of the low. Now, unfortunately, that's where most of the cooing is happening, because when the municipal ordinances are in contradistinction to the hierarchy of law, the judiciary is supposed to weed those things out and correct them. Well, when they cooed the judiciary by bringing a foreign bar union in and preventing the common law, which, as you can see, they completely changed the hierarchy of in their legal mind, and put common law way down there under state statutes. And again, how can an instrument of a grant of law, which gives the formation of the United States corporate body and or the formation of the state of Ohio, be subordinate to the laws that created it? Okay? You can't confer sovereignty, which is the states as nations are considered independent sovereign nations in and to themselves. And they are also considered sovereign from the federal construct of the body of laws and able to operate independently. So how can a sovereign people be subjected to instruments of state whenever they're the ones that made them? So that is the paradox where people find themselves, and they've tried to talk everybody into believing this order, that the people are not sovereign and that the common law is subordinate to everything pretty much other than municipal ordinances, because it's a coup, people. It's a coup. But the fact of the matter is the will of the people is what makes the state lawful. And so in being de facto, if they are not expressing the will of the people, or if they're trying to tell the people that they don't have sovereignty and they don't have the capacity to define whether a government is lawful or not, That right there tells you that your government is not your lawful government and that they have been couped and they're not operating in the interest of the people. The mere structure that they bring forward and argue that the common law is subordinate to statutes. Well, statutes only find their force in law by the will of the people through the legislature. So how can the common law of the people demand that their legislatures create laws and statutes, as statutes, little l laws, and then say that it's subordinate to those statutes themselves? That's the structure itself that they're showing you and telling you shows you that it is an overseen foreign instrument, that it is power from an outside source down that's being oppressed upon the people instead of the cycle of law where the people create the law and then reaffirm it to the judiciary and all that stuff. So what has happened is, since the municipal powers have no checks and balances anymore because your judiciary has been couped by a foreign body and foreign union, the municipal powers have gone crazy. And what you have is people who are being forcibly put into municipal corporations, which, by the way, a municipal corporation is also a court. A court is a municipal corporation. And in the fact that they have been couped, and they are the most prevalent source or location where the coup occurred, people are being subjected forcibly to the jurisdictions of municipal corporations with no checks and balances in the law. So basically what you have is you have a bunch of attorneys running courts, which are not courts, they're banks, but they're banks disguised as courts, and they're affecting commerce and enforcing peonage and slavery upon you by engaging you in unlawful, ultra-virus constructive contracts that you don't even know you're in. But the courts aren't courts, they're banks. They are municipal for-profit corporations that are 100% controlled by a foreign bar union coup. And because they couped the judiciary, they have been able to exercise this fake legal non-de jure law made by, again, the couing entities themselves that have prevented the checks and balances of requiring municipal ordinances and the agents of those, like the police, who are corporate agents. They are not constitutional agents. But those municipal corporate agents of police are being allowed to operate in whatever way their foreign coup masters are telling them to operate. Because most police departments don't do anything without the prosecuting attorney, who is a foreign agent by the law, by the de jure organic constitution. He is an instrument of foreign power. And he is there to extort the lands just like the Romans did in all of the other places they have ever occupied. So, there are a couple things that you need to review, and I will tell you that I can bring forth, as I said, the case law that says that municipal ordinances are supposed to follow the law. They're supposed to follow the organic law. This is their own corporate court. The municipal powers, are supposed to follow the organic constitution. Okay? They're not. I'll give you case law for that. Also, it's important to note that the construct of being a resident of a municipal corporation, when you go into a court or anything and they ask you, are you a resident of the city of Chicago? Which the city of Chicago is a municipal corporation whereby they have the, quote, legal authority to force you to be a resident of that overlaying jurisdiction, which, by the way, is unconstitutional. They can't force you to be anything. A res is a thing. So when they ask you in law, that's the definition of a res. A res, R-E-S, is a thing. So when they ask you, are you a resident, they're asking you to identify yourself as a thing. And you go, oh yeah, I'm a resident of the city of Chicago. You've just defined yourself as an asset of the thing, the city of Chicago. And you are also agreeing to be forced to be under their jurisdiction of tyrannical occupation and corporate overlay that is vacant of the checks and balances of the Constitution for the States of America United, the organic common law. So the origins of the coup come from the removing of the checks and balances of our structures of government by the infiltration of all branches of government by foreign agents called the bar union. So that's a brief history, a very brief history, of the powers of municipal corporations and what they are. So again, in review, municipal corporations are forced corporate overlays which currently lack the checks and balances that were supposed to be there, that were initially put there by the organic Constitution, the Constitution for the States of America United, and you are currently living under Roman civil law as a vassal of the land. So that's the summary. I hope that helps.